All right, ladies and gentlemen, boys and girls, children of all ages, Happy New Year!
Happy New Year.
What is happening? It is good to see you, Matt. It's good to see Adam. How are you guys doing? How's your Christmas vacation? If you had Christmas vacation time,
Your job ever end, Adam?
Yeah, occasionally. I did do work over it. I had a brief that was due that it's going to be filed tomorrow, so spent some time working on that. Things got to get done. There's deadlines, so what are you going to do?
Right.
For sure. I've been doing the honey-do list around the house and getting the canning room done, and we had some nice weather, so I've been doing some stuff out in the yard, trying to get some things done I didn't get done before all the snow set in a while ago.
Yeah, it's been nice here too the last couple of days, so it's been nice to get outside and enjoy that.
You guys don't get a lot of snow down there in PA anyways, right?
It depends. On a regular basis, not really. If we get 6 inches, that's probably a fairly big storm in the part of the state I'm in. And then there's also been times where we got several feet, so it varies. But
like Buffalo, right?
Yeah. I think the largest one we got in recent memory was about 3 feet. But it just, it varies. I would say on average, like a decent storm around here is anywhere from 6 to 10, and it's usually like 2 to 4 or 5. And if there's a couple days in a row where it starts to accumulate, that's where it starts to become, different, interesting.
Right.
Sure. What about you, Charlie? What are you up to?
We've had warm weather. We had a little bit of a very, very light rain on New Year's Eve on Saturday, and I went outside to foolishly sweep the pine needles off my driveway in the rain because I'm sick and tired of these things, and I'm like, I know snow's going to be coming and it's going to be super slippy because the pine needles are already slippery. So I went out and shoveled. I went out and swept for a while, and then I woke up and I'm all congested and I feel like hell and having a hard time breathing. Yeah, let the good times roll.
There's a few times I was out in the yard working on the chickens and stuff. I just cleaned out the chicken coop between yesterday and today. And I was like, my nose is running a little. I'm like, this can't turn into a cold. I can't afford that. SHOT Show's coming up. I got to get it. I got to get the SHOT Show crud is where I got to get sick, right?
Yeah, I'll have a shot of NyQuil before I go to bed tonight.
You got a couple weeks to kick whatever it is, or infect everybody else. Either way, it's all good.
Either way is fine.
Just exactly. Shake people's hands, right?
Yeah, totally, totally.
So we had thought probably it'd be a well. First off, Adam, thank you so much for coming on. I don't think I've ever had you on any of the shows. I know we talked about it last year at SHOT Show at the get together party there at the Haas Brew or whatever the heck that place is. Can never say the name right. But never really had you on. So I'm glad that we were able to get you on the live show here with Charlie and I, and to speak some of or I should say, to be able to dumb down some of the legal jargon for the layman like us. Because I think that's, with all these lawsuits abound, I think that's going to be a value to a lot of people out there.
Yeah, no, I'm happy to be here and happy to certainly talk about that legal stuff. I've been doing it long enough where putting it in plain English is kind of something that I've gotten fairly good at.
Nice.
It's unfortunate that a lot of lawyers can't do that, or just refuse to. And candidly, I've been in conversations with lawyers where the stuff they're saying, I'm going, what are you talking about, man?
So it's not just us.
Oh no, most certainly not. I mean, there's been times where I've had to read, a page or an opinion several times to actually understand what it's saying. It's taken a couple times. I'll readily admit that. I'm sure there's some people that are going, oh, yeah, stuff like that's easy. But no, it is complex, sometimes unnecessarily so. There's plenty of lay people though that I've run across throughout my time doing this kind of stuff that have taken the time to learn themselves and are perfectly capable. So you don't have to be a lawyer to get it. You just have to be a lawyer to show up and practice law.
Gotcha. Right. Would you, as you were talking about that, and you being an attorney in the firearms industry is kind of a not a common thing, I would say. Would you kind of attribute it, when you were talking about it, my first thought was, okay, as an instructor teaching people about guns, there's people out there that can use guns and know how to use guns really well, and maybe even make a gun, but might not be able to articulate a gun part to somebody or how a gun functions as well. Would you say that there's kind of a correlation between, you know, a lawyer in the industry being a really good lawyer but not being able to articulate it in layman terms, and an instructor in the industry being a really good firearms person but maybe not being able to articulate it as well?
Yeah, and I don't think you don't even have to limit it to this industry. I think generally speaking, there are people that are experts in their fields, but they can't communicate their knowledge in a manner that anybody else can consume. You know, it's a communication problem, I think, at the end of the day. They're not good communicators. They may have you know, vast arrays of knowledge tucked within their head, and they just can't find the words to convey that knowledge to other people. So yeah, I think I don't think it's limited to the firearms industry at all, but it is. I do see it here for sure.
Definitely. Cool.
So what are some things that I mean, the great thing about the SAF is they're the ones that are doing a lot of the hard lifting and the hard work behind things. I like having the NRA, and I like having the SAF and all the other groups as well, because I think the NRA takes all the arrows from the anti-gun folks, and the SAF can get stuff done while the NRA is holding up this big shield. And I don't want the anti-gun folks to find out about the smaller groups that we have that are putting in all of the hard work to make these things happen. So I just forgot where I was going.
Well, I mean, so you brought up SAF, and for those that don't know, and there's plenty of people who don't, the Second Amendment Foundation, it was founded in 1974, so it actually predates NRA's ILA. I think it predates ILA. That or the Citizens Committee. My mind is blanking, so I apologize. But one of the groups, either SAF or the Citizens Committee for the Right to Keep and Bear Arms, which is the sister C4 of SAF, they were started in the early 70s. And since then, you know, SAF in particular has built a foundation through scholarly work, education, and things like that ultimately, you know, led to Heller. Certainly, SAF didn't do it alone, but it was a major driver in funding a lot of these scholarly pursuits. This idea of things needing to be in law journals, and we need research and things like that. And sorry, bear with me 1 second. I apologize.
It's all right.
Go. New dog. Okay. So
Want that on the floor.
Yeah, right.
He's a baby. So anyway, so SAF for the last 40 years has been kind of leading the legal arena in things. And this past year, I think, if memory serves, we were responsible for at least 19 new cases. I think it was either 10 or 11 states.
Wow.
There's been 250 cases, over 250 cases since the time SAF was founded that it was involved with in some form or fashion. So either as an amicus party, thank you, gun websites. I appreciate you. I was correct. Both predate NRA ILA. And so the 250 lawsuits in which we've been involved in, either as a direct party, an amicus party, or as far as funding a case where it wasn't appropriate for us to be a plaintiff. And if you look at the laundry list of wins SAF has had over the years, you know, McDonald versus City Chicago was a massive one. It incorporated the Second Amendment against the states through the due process clause of the 14th Amendment. So every decision that's been against a local municipality or a state stems from McDonald. You had Wren, DC Kerry case that got rid of good cause in DC. There was a case earlier this year in which Tennessee, the Public Housing Authority, could no longer ban firearms in public housing. There was a lot of other lawsuits as well that I can't keep track of in this case, and those are ones that are completed. As far as things that were filed this year, you know, Oregon, we challenged the magazine capacity ban, the permitting system as far as the implementation. In Oregon, they basically they passed a ballot measure, and the measure said that in order to buy a gun, you need to have this permit. the permit system required stuff to be promulgated by the state police that wasn't done yet. It also required training that wasn't set up yet, and it was set to go into effect a month after the ballot measure passed. So essentially, it would have been just a total ban on anybody's ability to acquire arms in the state of Oregon. There were also a couple of assault weapons ban challenges this year, one in Connecticut, one in Delaware. SAF took over an 18 to 20 purchase case in West Virginia, which challenges the federal prohibition on handgun purchases. There was a bunch of things in California, including challenging that, I forget what the bill number was, but essentially what California did was they mirrored SB8 down in Texas, the abortion bill that made it a crime for people to assist with, people being able to get abortions. They took that, they basically flipped it and made it related to gun related stuff, and said that any lawsuit which was brought in which the people who brought it did not prevail on every claim. So you could win if you brought 5 claims, you could win 4 out of the 5 and still be liable under this. You could be sued for attorney's fees for the defendants, even if you mostly won everything you were looking for. So that was recently enjoined in the Southern District of California. And there's a lot of other stuff. I guess the last thing I would mention real quick while it's on my mind, the ATF rulemaking here as far as braces. SAF has had a brace case in the Northern District of Texas for about 2 years now. Back when ATF originally released that criteria, SAF had sued them. That case, I believe, is going to be our vehicle for which challenging this final rule whenever it's promulgated and comes out. So SAF was already working on the brace stuff long before everybody else was even thinking about it. And here we are. So quick blurb about SAF anyway.
No, that's awesome. That's all good information for people to know about. I was thinking about a couple things as you were saying that, and I made some notes here. So actually GunWeb's websites had popped up and said to be a life member. I know Charlie put it up. I'm going to put it up here again. So under $200 for a lifetime membership. So that's one way that you guys can help out if anybody out there is watching or listening, right? I've done.
What do they send you, Matt? What do they send you if you become a life member at SAF?
Nice plaque that says life member, and a bunch of other stickers and patches and flyers and goodies. So I actually, we had Alan on Meet the Pressers a while back, and when he came on, that's when I became a life member right after that. But on that note too, a couple things, other groups you collab with. I see that there's some lawsuits that come about, and when these lawsuits come about, sometimes they're a joint effort with other Second Amendment groups. How does that happen? Do you call up one of your friends at another group and say, hey, listen, we got this great lawsuit, but we need some more attorneys on it? How does that transpire?
Before you jump into that, I'm sorry to interrupt here, but we just want to let everybody know, for those people that don't know, back in October or November, you took the position of the executive director at SAF.
November 1.
November 1. There we go. So this is why you're very SAF oriented, because you're one of the folks working there.
Yeah, yeah.
one of the folks working there, right? So. I you know what I mean?
Yeah, I hear
your hands on a lot of the things that are going on.
Yeah. So Matt, to answer your question, a lot of the way that works, SAF has always, and even before I came to SAF, this was something I tried to do, always collaborated with groups for any number of reasons, like, good neighbors are good neighbors to have, right? Particularly when you're a national group and you're coming into somebody's backyard to deal with something in their state. A lot of times state groups in the past had, as a general matter, don't like it when national organizations come in because, it takes funding away from them, et cetera, et cetera. SAF has worked really hard to develop good working relationships with the partners we find, where, we'll collaborate with them, and, maybe we'll pick up the tab on things. They help find plaintiffs. They fundraise off it. We don't care. We're looking at the bottom line here, which is getting that law overturned, assuming it's with a lawsuit. And so we've worked very hard to build those relationships with groups. If you've ever been to GRPC, Gun Rights Policy Conference, you'll see a lot of the state group people will show up. It's a great place to exchange information and things like that. So, as far as attorney selection, it depends who's involved. if we're going into some state, generally we'll need local counsel. So sometimes the state groups will know somebody. Sometimes if we partner with another national organization, they'll have already, selected somebody for that. So there's any number of ways it comes up, but generally it's, we're looking to be a good neighbor and find ways to collaborate to be able to push back on these laws that get passed.
Good to know. Good to know. You had mentioned plaintiffs, and with that, it makes me think, like, as an instructor, I've got thousands of people coming through my classes constantly, and I'm always hearing the, their state's making me come and do this and make me do that, and I can't. So, how do you seek out plaintiffs? What's the best way to find plaintiffs? And my assumption would be that they'd have to contact you. You can't necessarily approach them. They'd have to contact you and say, hey, I want to be a plaintiff. This is the state's infringing, or the federal government's infringing on me. And I want to, be a plaintiff underneath this lawsuit, or can we form a lawsuit to help fix this wrong?
Yeah, so there's a couple things there. First, you need an idea for a lawsuit that's actually going to get done. So that's idea number one. Sometimes the idea starts within the organization. We'll look at the general map and go, okay, here's the legal landscape. Here are our priorities. These states look like good targets. We need to find plaintiffs with these particular criteria in these states. There's nothing that stops us from soliciting plaintiffs as an organization. As an attorney, that would not be okay in a lot of states. So there are some ethical rules about that. But generally speaking, the organization can do that. So if you ever see like an email or social media post or anything like that says, hey, we're looking for plaintiffs that meet these criteria, there's nothing that stops that. So either the idea is born in-house as to the lawsuit we're looking for, and then we'll work with like partner organizations, or if we have contacts within that state that may know people, we may go direct to them to avoid like the public, hey, we're doing this before it gets done. The other way it happens is, as you said, somebody says, hey, I've got this problem, and they contact us, and we look at it and we go, okay, well, maybe it wasn't something we were thinking about doing, but there's a huge public benefit if we're successful in this. And it fits generally within our agenda or what we care about. So let's go look deeper. So then we'll evaluate the person to see whether they'd actually be a good plaintiff, what skeletons they may have buried in their closet that could be problematic in litigation. And after we do all that and they look good to go, then we get a lawsuit ready to go and get it filed.
Good to know. That's all good information for sure.
Plaintiff stuff is it can be difficult at times, particularly these younger, like 18 to 20 cases that we have going on. Getting younger individuals to be responsive, I've found to be very difficult. I'm not sure the best way. Even texting them at this point is just kind of not the best. So that's been a little frustrating.
And they're going to run our country eventually. That's
right.
Scary.
I have a hard time seeing Alan Gottlieb Snapchatting somebody.
Yeah, he may not be, but I don't know. 18-year-olds are going to be 18-year-olds. I can't say that if I were 18 and trying to be in a lawsuit that I would like to believe I would have been more responsive. But it is what it is. Maybe we should try Snapchat.
Yeah, for sure.
Right.
Just not OnlyFans.
Right. Alan Gottlieb's going to do a TikTok video dancing around trying to get people to be plaintiffs. I have a hard time seeing that.
But if he dances on the Second Amendment saying, this is what the state and federal government's doing to you.
Right. We need a Second Amendment rap. Exactly.
For sure. So Adam, can you give us a rundown on the lawsuits that you're privy to, and as well as other ones in the nation that you think are key players that are definitely ones that us peasants should get behind and support and be knowledgeable of?
I would love to. I'm going to have to pull up my spreadsheet here because I think SAF has about 40 active cases, give or take.
Wow. That's amazing.
Yeah. All right. So we also filed a New York assault weapons ban challenge last week. I forgot to mention that. So there was 3 last year. So there's a New York assault weapons ban. We're Delaware and Connecticut. We're pretty heavily invested in challenging these new laws that have been developed after Bruin dealing with sensitive places. So New Jersey, there was a lawsuit filed there earlier in December. There's two going on in New York. One challenged the ban in places of worship in New York. The other was just a more general sensitive places challenge. So those are all going. The stuff in Oregon I shared a little bit earlier. There were a couple of challenges in California. One to Glendale's ordinance banning possession of firearms on city property. The ones there were two that dealt with prohibiting sales of firearms, ammunition, and accessories on different fairgrounds in different counties. There's a bunch of 18 to 20 stuff going on. There's a New York City stun gun and taser challenge. Yes. There's a really interesting one out of Pennsylvania that that I really like because I worked on some of the precursor cases to this lawsuit. Well, one of them in this particular one. So in Pennsylvania, in the I want to say it was like 2016, there were two individuals who were prohibited because they had committed offenses that were punishable by more than 1 year imprisonment. They were nonviolent misdemeanors. They brought challenges with Alan Gurr as their attorney, and SAF backed these cases. And the challenges were Second Amendment as applied challenges. So they went to court and said, look, this general prohibition in 922G1 that says if you're convicted of an offense punishable by more than 1 year imprisonment, or a state law misdemeanor punishable by more than 2 years imprisonment, that's unconstitutional as applied to me based on what I did. And they were actually successful in their challenges. So when I was in private practice, we did a couple of Second Amendment as applied challenges. One was for a individual who was convicted of forging a window tint exemption here in Pennsylvania, and that was a misdemeanor of the first degree. So that was a federally prohibiting offense, and because of that, that guy could not own or possess firearms or ammunition anymore. So we brought a challenge to that, and we were successful in that challenge. These three individuals, the two in the SAF case and this individual, then applied for a license to carry firearms here in Pennsylvania, and they were denied those licenses. The state said, like, you're ineligible for them. I forget off the top of my head what the criteria was, but essentially it was because they were previously prohibited, but their rights had been restored in the sense of court said that, like, yeah, these prohibitions were unconstitutional as applied to you. So we brought a new challenge that is challenging the ban on carry permits for those people. So I thought that was a particularly interesting one, and let's see. Hopefully that one's successful as well, and these people will be able to actually exercise their entire gamut of Second Amendment rights, particularly since, post Bruin, the Supreme Court said, like, well, Second Amendment means the right to keep and bear arms. Yeah. So yeah, like I said, there's a lot of cases here.
Yeah. Would you say that the Bruin decision is kind of open, especially with the way that the Supreme Court is laid out right now? Is the Bruin decision really been the floodgate to all of these lawsuits?
It's helped. I think one of the biggest things that we were kind of hoping for out of Bruin was the Supreme Court to come back and really clarify that test. And by clarify the test, I mean tell all those lower courts, like, hey, we told you in 2008 in Heller that this is the test. And since then, you guys have been screwing it up. And so they did just that. They came back and they said, look, the test in Second Amendment challenges is the text of the Second Amendment as informed by our nation's history and tradition. That's it. So you don't get to weigh away people's rights by interest balancing, saying, well, the state has an interest in preventing this from happening. And, we're going to apply this tier of scrutiny and, like, good enough. And, on we go. The Ninth Circuit was the most guilty of that. And I think there were 50 cases pre-Bruin that went through the Ninth Circuit. Not one of them survived or was a pro-Second Amendment decision by the time it was done. There were some panel decisions that found laws unconstitutional, only to go en banc, which means it's heard by the court as a whole. And then the court as a whole said, like, panel got it wrong. This is constitutional. So to answer your question, I guess, about the floodgate of litigation, it certainly helped for sure, particularly now that the Supreme Court said, like, hey, look, it's the right to keep and bear arms. Now you see all these challenges dealing with carry in any form or fashion coming out, and you see states that are trying to figure out how can we close down routes of carry?
So our chats are blowing up with active self-protection versus armed attorneys. So I want to ask you that question about first aid kits here in a second. But when we're done with that question and getting your take on it, I want to come back and talk about the different levels of courts, how it proceeds up through, because I think that's confusing to a lot of people. I get students all the time saying, "Oh, the court just ruled that the New York State CCAA law is unconstitutional. It means I can carry again, right?" And I'm like, "Well, hang on, let's wait to see what the next court says." And the stays and the injunctions and all those confusing terms. Charlie and I'd like to get your take on all that and clarify it a little bit and kind of give the viewers and listeners a stepping stone or a step process through all the different courts. But before we get to that, active self-protection put a video out. John Correa put a video out regarding the armed attorneys video, them saying that carrying a first aid kit could cause you liability if you have to shoot somebody. And in court, it might come out that you were trying to, you didn't save them, and you could have because you had a first aid kit, or you had a first aid kit, so you probably shouldn't have shot him in the first place, or something to that extent. Do you carry your first aid kit on you when you're out in public? Stop the bleed kit?
I've got stuff in my truck, but not on my person.
Gotcha. Do you find it that would be? Did you see either of the videos that were no?
Nope.
So basically, the armed attorney says it wouldn't be good for you legally to have a first aid trauma kit on you. Where John Correa, and I agree with John, active self protection is, yeah, you should definitely have one on you, because it's not just about how it's going to be perceived to help the bad guy. It's how it's going to help you. I get shot, I want to be able to put a tourniquet on me, or a quick clot, or chest seals. Same with my kid or a friend, or I'm at the Tops in Buffalo and somebody gets shot. I want to be able to help people, and I think that's the bigger picture in my mind.
I've seen some videos of John Correa, and he said that he carries a first aid kit because he's seen accidents on the side of the road, and he's been able to render first aid with his
and that's more likely than a gunfight.
Right, exactly.
But anyway, I'm taking away your thunder, Adam. What do you say?
No, you're not at all. So I was actually sometime, I think it was either last year or the year before, I was going to dinner, driving down the highway, and I saw some very faint lights off the side of the road. And as I was driving by, I saw that there was a car overturned. So I stopped and went running back to the car, and several other people stopped ahead. One was a firefighter who came running back with a first aid kit, and got on the phone, called 911, put him there. And fortunately, she was a younger girl. She couldn't have been more than, I don't know, 20. She had crawled out and was okay. But like, that was one of the impetuses for me, and I probably waited far too long to actually do that. But to throw one in my car, there's some good Samaritan laws out there that if you do render aid, I mean, I'm not a medical expert. I think there's things where I would look at it and go, you know what, I could probably do more harm than good if I try to render aid here, so I'm just not going to do anything. But I think that decision's kind of a personal one, and skill and knowledge set. As far as what a court will look at, it's all conjecture in a lot of ways. I don't know. If you shoot somebody, you're either justified or you're not, right? Like, do you meet the criteria for self-defense? Does the first aid kit play into it?
Yeah.
I don't know. I mean, I guess if a prosecutor wants to really go down that road and try and hang their hat on it, could they? Sure. Take, for example, there was the one long time ago, there was the case, I think in Arizona, where a guy shot someone with a 10 millimeter, and the fact that he used 10 millimeter was brought up against him and kind of used to skewer him. And then there was the, not quite the same, but the one officer who shot that individual in the hallway that had the dust cover with the, your effed on it. Do those things matter? I don't think, generally speaking, but if you take the whole circumstances and you look at the whole picture, can it play into it and potentially be used to railroad you? Yeah, possibly. Is a first aid kit going to do that? I don't know. And I'm not going to weigh in on that, solidly one way or the other. But I, like I said, I carry one in my truck. I carry one in my range bag, because again, like, if I get hit, somebody I'm with or somebody at the range gets hit, to be able to render aid till somebody else can come. Probably useful.
And the way that I'll explain it to my students is if you if you pull your firearm out because you feel death or great bodily harm and you shoot somebody to defend your life, and then you put the gun away and then go over and provide medical aid to them, could they still be a danger based on having some communicable disease, based on, being, them being shot and acting like a dog that's been hit by a car? I mean, your dog you grew up with, it gets hit by a car, and you go over to console your dog's going to, lash out and bite you because it's in agonizing pain. Now, the person you just shot, you're going towards them to provide medical aid. How do you think they're going to feel? Like, you're coming over to finish me off? You don't know. So, not to mention, they could still be a threat physically or with other weapons. I tell people, if you have to use your gun in self-defense, your best bet to help that person is to call 911 and say, please send medical professionals, and let the medical professionals render first aid to that individual. That's what I tell my students. But having that tourniquet or first aid on me for other reasons other than that, absolutely, is my take.
Yeah, there's plenty of stuff in life that can happen where you may need to render aid, and it doesn't always involve a gunfight.
For sure. The reality is most people won't be in a gunfight, thank God. Yeah,
Right.
do smart things. All right, so back to those levels of court, and that stepping process of it getting up to the Supreme Court, and all of these terms, injunctions, and restraining orders, and stays, and enjoinments and stuff. Can you shed a little light on that, like the process in a quick elevator speech, how it makes its way up, and what these terms mean?
Yeah. So let's start at the very beginning, right? There's two different court systems. You have the federal court system and you have the state court system. They're not the same. The only time a state case goes into there's two ways a state case could go into a federal system, I suppose. One is where the case is removed to federal court. We're not going to get into it. The other is where there's a state Supreme Court case that's decided, and the parties petition the U.S. Supreme Court to weigh in on a constitutional issue. Generally speaking, though, you have your federal courts and your state courts. Most of the work we do is in federal court. Almost all of it is actually in federal court. So we'll cabin the discussion to federal court. So the federal court, you have three different layers, if you will. The very bottom layer is the federal district courts, and those are the federal courts trial courts. So that's the lowest level. That's where you bring your lawsuit. There's a couple things that can happen there. In the beginning, you can seek what's called a preliminary injunction, and if that's granted, what that means is the party that you've sued is enjoined or cannot engage in some behavior that you ask the court to prevent them from doing. So in our context, it would be enforcing this law that was passed. So take, for example, Oregon. We'll use Oregon as an example. We sought a preliminary injunction seeking the state to be enjoined or stopped from enforcing that ballot measure. And all that does is it maintains the status quo, right? So new law going into effect, hasn't gone into effect yet. We're just maintaining the playing field as it is until the court's able to hear the case on its merits and then decide, yes, this is a constitutional law, or no, it's unconstitutional, and then it either may or may not go into effect. If you lose a preliminary injunction, you can appeal that decision up to the next level court. This is what's called an interlocutory appeal, and what that means is the case that you have in the trial court continues to go forward, and the appellate court deals with this issue. In this case, the denial of a preliminary injunction. There are, why is my mind blanking on this? I think there's 13 circuit courts. They cover a variety of different states. So, for instance, the Third Circuit is Pennsylvania, New Jersey, Delaware, and the Virgin Islands. The Ninth Circuit's a much larger circuit. It has California, Hawaii, Oregon, Washington, Idaho, Montana, Nevada. There's probably one or two other states I'm missing. So you can look it up if you're interested of how they're divided up. So anyway, going back to the district court for a moment here. So assuming you don't do anything with preliminary injunctions, you have your case and it goes all the way through the district court, at which point at the end, the district court makes a ruling. And they'll either say again, the law is unconstitutional, I'm enjoining the state or municipality or city from enforcing these things, or it's constitutional and hey, people, you brought the lawsuit, you lose, too bad. From there, almost guaranteed that somebody appeals that, and then we're back in these circuit courts that I was just talking about. The circuit courts, they are not the trial court. So what that means is anything that's factual or evidentiary nothing new gets introduced there. That's all done in the trial court. So at this point, they're just looking at the record that was developed
Transcript,
and
right?
yeah, transcripts or prior briefings done all over again. But there's nothing new that's added. So if you go, oh man, hey, like um, the smoking guns over here, and we forgot to introduce that into evidence.
Too late.
Too late. Generally speaking, for new things like that. So the court there will review the lower court's decision, and depending upon the basis for the appeal, there's a couple different standards that are used. But they're looking at the record, and then they'll make a decision as well, whether it's constitutional or unconstitutional. As I kind of mentioned earlier, they have a panel, so it's 3 judges that'll sit and hear it. If you're unsuccessful at that stage or the other side loses, they can petition the court for en banc review, which means, again, that the court as a whole will sit and hear this case and potentially overrule or agree with what the panel decided. At that point, there's one of 2 pathways here. You have your panel decision, and you can either ask for en banc review, or you can go straight to ask the Supreme Court to hear the case. If you ask for en banc review and that gets denied, then you can ask the Supreme Court. So either way leads you to the Supreme Court if you're so inclined. The Supreme Court here in the United States has original jurisdiction in only a few instances, which means that they're a discretionary court, and unlike the appellate courts below, they don't have to hear every case appealed to it. So what you're doing is you're filing a petition for certiorari, and you're basically asking, hey, would you please hear this case? Here's our compelling reasons that you need to do it. And the Supreme Court, when looking at things as a very broad statement here, looks to find things that are unresolved amongst the circuits. So say the Ninth Circuit decides a case one way, the Third Circuit does it a different way, and there's a couple other circuits. They're looking for a circuit split so that they can say, like, hey, this area of law is unsettled. We need to come in and make it uniform so it applies evenly across the country. Or there's some times where there's like a really compelling thing that they just need to deal with, like some of the election stuff or something like that. So that's the very quick down and dirty court system, I guess.
That's awesome. And I think some people don't understand or don't get either that sometimes in court, they'll, just like a DA might decide in a certain way so it doesn't go up, so there's a rift between the circuits so that the Supreme Court doesn't take it up. And that example I use is with the taser in New York State in District 2, back when District 1, I think it was Massachusetts, back in 2013, they ruled that tasers and stun guns are covered under the Second Amendment. And then here in District 2 in New York, it went up to the district court, and that district court judge he said, yep, nope, they're covered under the Second Amendment, versus saying no. And then obviously if he said no and First District said yes, well, now there's a rift and the Supreme Court could take that up. But then in New York, what they've done is they basically sat on their hands and said, well, we'll put a bill forward, Senate bill forward, to make them legal, but it's never gone anywhere. Since 2019, that bill's just been sitting in limbo. Senator Hoyman's office hasn't done a damn thing with it. It's been in committee.
Yeah, so sometimes, maybe if judges are playing politics, but sometimes it's a party decision too, particularly if a defendant loses. How much am I going to screw up this area of law for other places that may want to be doing the same thing? So there's a lot of
politics.
There's a lot of gamesmanship, for lack of a better description, like choosing where you bring the lawsuit. And they teach you all about this in law school. It's not like it's some secret, but like venue selection, like can you get into a favorable venue where you're going to have a better result than somewhere else?
Sure.
Sometimes you're just stuck where you are, right? Like California is California. They're passing a bunch of laws. So it's not like we can go to a state like, I don't know, Texas and challenge these things and get favorable results because they just don't exist there.
That's smart. I mean, it's you got to play it just like we do. Well, am I going to go out to this part of town? Well, no, there's riots going on down there. Well, I'm going to go to this part of town. It's a little safer. Right? It's more favorable for me. That kind of thing. It's smart. And I'll explain that to people in New York too that are complaining about the new CCAA law and how they're basically circumventing the Supreme Court's ruling in Bruin. I'm like, well, we didn't do it any differently when the SAFE Act came about. We found ways to basically circumvent the SAFE Act by having pinned magazines. It's no different. It's just trying to find a way to be legal under the law that you don't agree with. I mean, we did the same thing with the SAFE Act as that they're doing with the Bruin decision here in New York, unfortunately.
Yep.
Someone here, I know you brought up Oregon earlier, but G23 asks, what is your feeling about the Haney Court Oregon judge with Measure 114? And G23 has been live streaming the measure, the court hearings.
Yeah, so I haven't seen any of those. I'm aware of the opinion there and the injunction against the state from that. So that's certainly good for everybody. Not our lawsuit, but step in the right direction. So we'll ultimately, I think, see where that ends up. Whether they're successful in getting a permanent injunction in that case when it's all over.
Gotcha.
Another thought I had with you talking about it going up through the courts like this. Some people fail to realize as well, and please correct me if I'm wrong, just because the court rules that it's one way, especially the Supreme Court, they rule on something like they did in Bruin, they send it back down to the lower court to correct it. So it doesn't automatically change the law. And I think a lot of people hear this judge rules this way, and that means that it's null and effect immediately. And it's not the case. It's still in the books. It's still illegal in the state, even though the higher courts ruled. It still doesn't remove it from the law until the legislator removes it from the law or changes the law.
Yeah, sometimes. So they'll like vacate. They'll do what's called vacate and remand. So they'll basically say like, "Hey, lower court, your decision is wrong. So we're throwing it out, and we're sending this case back down to you to fix it in light of what we said in our opinion here." So that happened after Bruin. That happened in a couple of cases that were up at the Supreme Court that were Second Amendment cases that were waiting in the court, granted cert on all those cases, vacated the circuit court's opinions and sent it back down to the circuit courts to say, hey, in light of Bruin, redo it. And a lot of those circuits actually looked at it and said, like, hey, trial court, in light of Bruin, redo it and then send it back up. So some of that, I think, was also a delay tactic, perhaps, on some of the less than friendly circuits as far as being able to keep things at the current status quo as long as they could.
Someone has this idea that we should have a law school house rock called Injunction Junction. And I think this could be Alan's ticket on TikTok. I really do.
Yeah,
so we'll come up with some lyrics.
That'd be funny.
No, it would. That's something that I talked about years ago about a schoolhouse rock type lawyer thing. But I'm not an animator, and I'm not very musically inclined, so my lyrics would not be very good.
Right. Oh my gosh! So going back to the 18 to 20-year-old, after I interviewed you in Dallas at the Gun Rights Policy Conference, I went back to my day job, and I was in a library in a private school, and there was a book that was called Faces of Gettysburg, and on it was pictures of people that fought in the Gettysburg Battle of Gettysburg, I think I'm not sure what it was called, but anyway, I would flip through this book and I would see these pictures of 18, 19, 20-year-old people with swords, with some rifles and shotguns and all sorts of long firearms. And I made a video of me borrowing this book from the library, and I added like the Mission Impossible music, and I replaced the one book with a different book. So I put in the Indiana Jones music there. And I brought this back, and I'm like, this is going to be the book that cracks the case for the 18 to 20-year-olds. I don't know if it'll help. But if I need to borrow this book again, please let me know. I'll grab it.
So, I mean, in a lot of our briefing in the 18 to 20 stuff, particularly, with the law firm we work with, and one of my former coworkers has done a lot of research in that area, and it's perfectly clear that at the time of the founding, like the Second Amendment applied equally to 18-year-olds just as much as somebody who was 45. A lot of times the government tries to tie it to the militia laws, but the court has said like the Second Amendment is independent of militia service. So it really shouldn't be this difficult of a decision. Again, I think it's policy making that's being interjected into legal analysis.
For sure, for sure. Do we have any questions?
Yeah, I just sent a message out to see if anybody had any questions.
Anyone has anything?
Did you put this one up for gun webs?
Oh, I did not see this. Oh, we have a very large community asking
Stealing my idea
creatively. I know, right? This is what happens when you put it up. We need some people to contribute creatively to the Schoolhouse Rock collaboration. It should be very powerful and useful. I think it'd be great. I think it'd be hysterical, is what it would be. That would be really
it could be.
So how can individuals support your guys' efforts? What are different ways? I mean, obviously monetary is one, but are there other ways for people that maybe can't afford to chip in but might still want to help out?
Yeah, so certainly monetary is absolutely awesome and the best best way. And for that matter, like even $1, like whatever, it doesn't have to be a $5 million contribution for it to be impactful. Like if everybody gave $1, you start talking some serious money when you start looking at like a lot of people giving $1. So other than that, certainly letting people know that who we are, what we do, that information, SAF.org, so SAF.org is our website. Social media is going to start picking up here, but just even spreading awareness about the organization and the work that it has done and is currently doing, I think is probably one of the biggest ways in which somebody can help. There's no shortage of people that just don't understand or don't know, about the work. And I think, that's being up on the soapbox and telling the world. Sometimes you got to have people do it for you. So
for sure.
That would be probably the best thing somebody can do other than monetary donations.
We hear all the time that there's 100 million gun owners, and then you hear that there's only 5 or 6 million members of the NRA, and the number of people that are life members of the Second Amendment Foundation is even smaller than that. And if we had more of these, more gun owners that were sending in some money and donating, and $20 a month or something, it's really not too much money to put that in your budget and to send it to one of your favorite pro-gun groups, pro-rights groups.
Yep.
Yeah,
well, certainly.
With that whole those boxes of liberty, you kind of hit a tone with that. It's our Patreon. We use those for soapbox, voting, jury, and ammo. And really, we're at that voting and jury aspect where we can see, like in New York, voting even for somebody to go against the norm here in New York is tough. And you guys see that a little bit in Pennsylvania as well, and obviously other states like California and New Jersey are dealing with it a lot, like New York is. But you are the forefront for that jury, Second Amendment Foundation, and you yourself being able to change it in the courts. And I think that you are that last guard before something else happens in this country that I pray never happens. But it is definitely a push. We need to get behind organizations like yours and definitely help you guys be able to turn the tides before the Supreme Court changes again.
Right.
Yeah, I think certainly there's a lot of work to be done. There was a question here I saw that popped up from gun websites. Yeah. So I thought that was a really good question. And when you look at the decisions in the Second Amendment world, particularly at the Supreme Court. So if we exclude Miller from this for a second, you have Heller in 2008, which says that you have a right to keep arms. You have McDonald that incorporates that decision against the states 2 years later. You get Catano, which says that, look, electronic arms are protected under the Second Amendment in a per curiam opinion. And then you have Bruin, which says that there's a right to bear arms. So when we're looking at the field, well, what's something that's currently being litigated everywhere? It's you're looking at like assault weapons bans and types of firearms that could be owned. So I think if we're talking like the next thing, my guess is if there is going to be another case that the court eventually takes, it'll deal with the types of common arms in use for lawful purposes, and arms being, both firearms and magazines being the other part of that equation there. And not aware of any court that has found magazines are not arms under the Second Amendment, except for, I take that back, I think there was a decision the other week where a court said that they're not arms. I'm trying to remember where that was. Preliminary injunction somewhere, but every circuit court at least says that, like, yeah, magazines are in fact arms, and I think they've struck down all the challenges to magazine restrictions based on the two-step test that no longer exists post Bruin. So yeah, you need another case, because you're going to need to for somebody, the Supreme Court, to step in and say, like, hey, these are under Bruin and what we told you in Heller, like, these are protected by the Second Amendment.
Well, and if they've been trying for years to attack the guns and the individuals, and when they realize that they're not getting what they want, they start going after the ammunition and the magazines. So, you know, it just makes it harder. If you can't feed your gun, there's a plug for our friend there, Patrick Collins, the gun food.
The gun food.
You can't feed your gun, then you can't use your gun. So I think reloading. I was surprised after the riots. I'm sorry, the peaceful protests, that you know, there wasn't more people taking up reloading, actually.
Well, I think things were hard to find.
Thankfully, right? Components are nuts.
Yeah. Does the Supreme Court not take cases? Like 2008 was Heller, 2011 was McDonald.
2010.
Yes, sorry. And then we had the couple of Estelle cases. Does the Supreme Court try to avoid gun cases to kind of, I hate to say, keep the people at bay, or to not have more civil unrest and have more peaceful protests?
So I'd be lying to you if I told you I knew how the Supreme Court picked cases other than what I shared earlier. There's a lot of secrecy in how the Supreme Court operates. There's a lot of people who have clerked there, and lawyers and people who study that provide guesses and stuff. But the only people that are going to know how a case is decided, or what they're going to do, are the justices sitting in the room during conference looking at petitions going like, cool. And then they vote. And if they have enough votes to hear a case, then they'll hear the case. Sometimes, potentially, there may be some strategic declining of taking cases where a justice may think that the issue is very important, but not think that there's enough votes for the outcome that they believe to be based on the law to be correct. And they may avoid taking a case in order to not have bad precedent that affects an area. So would I tell you that the Supreme Court avoids gun cases? I mean, outwardly, the appearance seems like it does, but is that actually the case? Couldn't tell you.
Okay. Someone here's got a question. It says, I know you declined the position on the NRA Board of Directors, but what can be done? What can we do as members to get the NRA back on track? Not only with the 2A issues, but staffing for education and training and competitions, etc.
I would tell you to talk to the board members of the NRA on that one. I don't get involved in other groups' politics, and I wish NRA the best. I've got friends that work there. Would like to see them successful and in better shape than they are. But my best would be find a board member that's willing to listen to the members, and chat with them. I think there's a couple that were recently elected that are going to be up that road for you.
Gotcha. I want to put a plug in for Amanda Suffolcool and Rick Ector. So if you are a voting member of the NRA, they are two very good friends of ours, and they bust their hump for the Second Amendment and everything that they do. So when the elections happen, please support those two.
And I think that's what needs to happen, right? You got to start overtaking the numbers, just like we have the Supreme Court. I don't know if you put this one up or not, Charlie, but there's another question here, Adam, if you can see that one.
Yeah, so JPFO, for those that don't know, is the Jews for Preservation of Firearms Ownership. I honestly don't know. I know that Alan does have involvement with the organization, but I only work at SAF, so my knowledge of these other groups and what they're currently doing is limited or non-existent, just because I don't have time to focus on any of those.
Okay, here's another one.
Plaintiffs. plaintiffs' ideas, if there's something to collaborate on, for sure, we'd be interested in talking.
Do you have a form on your website where somebody could go and submit a suggestion or?
Yeah, I think there is a spot there. You have to bear with me 1 second because I saw it the other day and I honestly don't recall where I saw it. But I do think there is one up there. Also, you could just use the contact us, and that would be probably the easiest way for me to tell you without digging around trying to find the.
That's fine.
That's quite all right.
All right.
So somebody posted here that Frank Tate is now a NRA board of directors member. I think someone passed away, and Frank was like the next guy on deck.
Yep.
And,
yeah. Frank's a local guy that I know from back when I worked in the gun shop. He's a good guy.
He is. Yep. I've had him on the show. I thought he was a lot of fun to be with. He's got some great stories too, which is always cool.
Yeah.
All right, listen, we need to kind of wrap things up. We only have a few minutes left. Before we have you plug SAF and tell everyone to join SAF at saf.org. Matt, let's remind people about the giveaway that we're doing.
So meetthepressers.com/giveaway. We're giving away 2 certs thanks to our sponsors, Next Level Training. We're giving away a green cert and a red cert at 2 different times during the month. And this year's code is SAF. So anybody watching the show can go to meetthepressers.com/giveaway, enter the code SAF in the form, and you'll get entered. And right now, Adam is going to pick a number for last month's second giveaway. And that's going to be pick a number between 1 and 31. Adam?
15.
15 is Misty Hensley.
You're welcome.
Misty Hensley.
There we are.
Yep. And just so everybody knows as well, we've changed it where if you actually subscribe to both Charlie and my channel, Meet the Pressers and Riding Shotgun with Charlie, you'll get another entry in the giveaway. So just so everybody knows, we're up in the ante to get you guys to actually subscribe to our channels so that we can build our following and bring you great people like Adam.
Yes, but you can only win one time, right?
Correct. Yep.
All right.
That is correct.
So we don't want anyone thinking that we're stacking the deck.
So in the last question I have for you, Adam, before you do plug SAF once more before we cut for the night, NFA. I recently got my Class 2, so I'm a Type 7 FFL with a Class 2 NFA dealer license. What do you see with all these wins and these cases going up towards the Supreme Court? What do you see with the NFA? Do you see that kind of changing, being challenged, maybe going away because of all the stuff that's happening? I mean, I hear people talking about it, but what are your thoughts?
I don't think so in the immediate future, and here's why. Right now, you have a bunch of courts that have said that the AR-15 is not protected by the Second Amendment. And magazines that hold more than 10 rounds are not protected by the Second Amendment. So I think you're going to have a very hard time in an upwards fight on trying to get a win saying that something like a machine gun or a short barrel rifle or silencer. Not to say that they're impossible, and certainly there's arguments, particularly if you're looking at the common use test, that like these are in fact, commonly possessed and used for lawful purposes, and therefore they are. I certainly personally believe they're protected, but I think if you're looking at it from a strategic, positioning, if this is the current legal landscape, I don't think that you're going to end up winning those cases going after the NFA directly when you can't even have things like AR-15s being declared, as protected by the Second Amendment. I would love to be proven wrong. Don't get me wrong. It would be nice to be able to go into the store and just buy an SBR or buy a machine gun and not have to do paperwork or pay thousands of dollars. So
wait a year and a half.
Yeah,
for sure. Cool.
Very cool. Plug away at the SAF, sir.
Second Amendment Foundation, saf.org. We are on Facebook, Twitter, and we do have an Instagram account that will hopefully be getting active again here in the near future. take a look for us in your local courtroom, not your local courtroom, but some federal court. Certainly pay attention to the work we're doing. And if you would enjoy what we do, I would certainly encourage you to consider donating to the organization. Tell your friends, tell your family. It's the best thing you can do is help spread awareness for us. And, we'll be here doing what we do, suing people.
It's a great punchline right at the end. Suing people.
We need to make that the new motto. The SAF. Suing people.
Maybe part of the TikTok. Yeah. So I challenge people, go and do what I did. Join, send the post up there, SAF, #SAF.
Yeah, please check them out. Listen, I don't know when our next live show is going to be. I know in a couple weeks we're both going to be out in Las Vegas. Are you going to be at SHOT Show, Adam?
Oh, yeah.
All right. Well, we will all have to spend some time together and maybe have an adult beverage and a cigar or something. And but we'll get something. If you haven't subscribed to the YouTube channels for Meet the Pressers and for Writing Shotgun, please do. And we have, Matt's got like 14 different Facebook pages. He might need an intervention, but I've only got like 7, so it's I'm not far behind. But please check out all of our Facebook pages and find out when the next show is going to be. And we will see you guys very much. Thank you guys for tuning in. Adam, thank you very much.
Yeah, you're welcome.